I think at some point I am supposed to get. I think at some point I am supposed to get. Moderation helps everyone feel safe. We need moderation. I think, and this is where you tell me that I'm wrong. Why don't you have this set up ahead of time? I could do another source, and I could do a window capture. I'll do window capture 2. Properties for window capture 2. And it'll be that. It'll be that. And can I make it smaller? And I want this to be down lower. So you'll see that, right? Then I'll do this. And I think that just makes it smaller. I think that just makes it smaller. I was trying to figure out a way to capture just a portion of the screen so that you guys could see chat. But I guess I won't. Deal with it much for now. Anyway, let's see. We want to close the moderation helps everyone feel safe. I don't think that moderation helps everyone feel safe at all. I mean, depending on how we're going at the end, I'm going to go over some of these at the end. I think I'll try to do my normal, go through everything at the end. Is the picture froze up? You can't see me, can you? Video capture. It shows that it's streaming, but then it doesn't show that it's streaming. Because it's never mind. Because I have my window paused. That's why. I'm what we like to call we as in small, Todd as in the name, did. We're going to start off with Springer. Springer versus the 7th Judicial District Court. Apparently, on September 5th of last week, the defendants got into the mix. Now we have all the defendants represented, and we also have filings from the defendants. So first thing we have is the main document. Let me take us a little peeky-poo. This is the defendant's response to plaintiff's complaint for declaratory judgment and injunctive relief for civil rights violations under 42 USCA violations of rights protected by the New Mexico Civil Rights Act. I don't know what the New Mexico Civil Rights Act protects. But don't tell Fraud or Wrangler that there are civil rights that aren't in the Civil Rights Act of 64, as he likes to say, because he's a fucking idiot. Emergency request for temporary restraining order, request for preliminary injunction, permanent injunctive relief, and damages. Comes now. Ugh. Comes now. Get it? That was a joke. Comes now. These people. Introduction. Springer seeks an injunction, barring defendants from limiting plaintiff's presence in the 7th Judicial District Courthouse to his own matters or specific court business, and with a law enforcement escort. Plaintiff's entire case is based on the premise that defendants are violating his First Amendment and due process rights. Plaintiff argues from a faulty premise. Well, this will be interesting because I did check the seventh Judicial District. Right? Wow. Why am I retarded? The 7th Judicial. I could just do this. But, there we go. So I had looked up Springer. Where was it? I had looked him up before. You guys are going to watch all the stupidity. Fees and filing. No. Oh, it wasn't here. It was New Mexico. New Mexico. New Mexico case lookup. That's what it was. I'm only half as think as you dumb I am. Well, I am not a robot, but you can't prove it. All right, and so we are going to look for Springer James. Is it one L? I forget. It's like Allen. It's Allen, but I don't know if it's Allan. I'm getting buzzed. Boys. All right. So we're going to go by filing date. I'm not seeing. So yeah, I remember looking it up. So there is, yeah. All right. That's what I want to make sure. All right. Plaintiff's entire case is based on the premise that defendants are violating his First Amendment and due process rights. Plaintiff argues from a faulty premise. First, plaintiff does not meet the legal requirements for an injunction. I thought he pled them. We'll be covering Shirley's motion about atomic clocks. I'm going to be covering Chile motions, and someone was posting about atomic clocks, so I believe so. I haven't read any of these yet because my week has been just fucking smashed full of dumb shit. But yeah, I intend to go over the Chile filings, time permitting. Second, the restrictions on plaintiff's access to the court are content neutral. Content neutral. They're specific to him. How is this content neutral? Well, I mean, this is orders, generally speaking. Oh God, they have a specific name for them. It's an injunction that they give to prevent future speech. God. Prior restraint. Thank you. Brain not working so good. So this isn't really a forum analysis or a. I mean, the restrictions on his access to court are restrictions specifically on his access to court. So I don't know why they're going through this. So it'd be like trespassing with access allowed for specific things. But they eliminated those, I thought, because there were actual cases filed against them. I saw them previously and they disappeared. There were actual case numbers associated with these particular things. So an order of the court restricting your access to some place wouldn't be just like that's not a random law that you're looking at where you're looking to make sure it's content neutral and reasonable. This is about access. So this would be more along the lines of like freedom of association kinds of things, or news gathering. I don't know. I don't know where they're going with this, but I suppose if I keep reading, I'll get there. And so maybe I'll keep reading. Finally, Plaintiffs Acts 10. Plaintiffs Acts 10, is there a footnote? Plaintiffs Acts 10 of spoliation. Plaintiffs' acts of spoliation have negatively impacted defendant's ability to respond to his complaint. Spoliation, this would be interesting. Shelley would like a little bit of spoliation talk, right? Defendant reserves argument concerning immunity and the Pullman doctrine for future motions practice. Defendant respectfully requests that this court deny plaintiff's complaint. On or about January 27th, 2023, plaintiff entered courtroom at the 7th Judicial District Court to observe a hearing before the hearing officer, Gordon Bennett, hereinafter H.O. Bennett. C. James Freeman, sheriff and deputy, stand up against bad New Mexico judiciary, Gordon Bennett. I saw that video. It wasn't the win that Freeman thought it was, which is attached here to his Exhibit A. It's attached as Exhibit A? It's attached? How do you fucking attach it as Exhibit A? That's craziness. But apparently it's attached as Exhibit A. There's a link, but During this time, the state of New Mexico had a mask mandate in effect for its courtrooms. They did. However, when H.O. Bennett asked plaintiff to put on a mask, plaintiff refused. H.O. Bennett went off the record and left the courtroom to ask for assistance from law enforcement. Bitch! He's a bitch and he's a snitch. Jethro Tull getting his drink on. You go, bro. Sir and or madam, excuse me. I'm in California. I can't assume your gender. Upon H.O. Bennett's return to the courtroom, he asked plaintiff to identify himself. Below is an excerpt of their conversation. H.O. Bennett. What's your name? Plaintiff. I didn't give it. I'm sorry. H.O. Bennett. Inaudible. Plaintiff. Just trying to specate. Just trying to specate. Specate. Just trying to specate a public hearing. Nothing more, nothing less. You know, I hate it when I'm on the toilet and I specate all over the bowl. Oof, it's bad. Specate. Spectate? I'm going to go with spectate. Ho Bennett, I can appreciate that you're here to specate. So, specate must be a word. So what the fuck does specate mean? What the fuck does specate mean? I don't want spectate. I want specate. It's a Minecraft plugin, apparently. Okay. Specate. I can appreciate that you're here to play Minecraft, and I can appreciate that this is a public hearing, but you're not going to violate the rules. Plaintiff says, which rules are those? H.O. Bennett says, put a mask on. Plaintiff, oh, you want me to put a mask on? Tell you what, if you threaten me with arrest, I'll just leave. Bennett says, I'm not threatening anything. I'm just telling you that if you do not abide by the rules of my courtroom, you will leave. If you choose not to leave of your own accord, you will be escorted. Plaintiff, stupidly, because Springer can only think in terms of arrest, isn't specate with two C's urban slang like finna? Finna apparently is now in the dictionary. It's now a word. You can write finna in your all of your paperwork. Finna's a word. So plaintiff asks, would I be charged, arrested, or charged with anything? Bennett says, well, if you continue this, I may charge you with contempt. Plaintiff says, okay, so there's a threat of arrest then if I don't do what you say right now. Well, no, a charge of contempt would not necessarily result in an arrest. I mean, it could theoretically result in a warrant for arrest or um, a sentence of jail time. It could theoretically. So plaintiff says, okay, so there's a threat of arrest then if I don't do what you say right now. The slow roll, the old Springer slow roll. Bennett says, would you happen to have your phone out now recording this? Plaintiff says, I mean, if there's a threat of arrest, I'll just leave. Bennett says, are you recording this conversation? Plaintiff says, the court is, there's a camera there. Bennett says, you're right, the court is. By statute and rule, I'm required to record. Well, by statute. Plaintiff says, tell you what, son, I'll just get a bigger team and we'll come back, sweetheart. All right, we'll be back. Tough guy, Springer. Tough guy. A different Jay-Z says, you're there. Well, I am here. I am indeed here. Thank you for noticing, a different Jay-Z. See also, James Freeman caught in a bald-faced lie by a camera in his own courtroom, dishonorable Gordon Bennett YouTube, which is attached here to as Exhibit B. And there's a link, apparently. Somehow, or sometime thereafter, plaintiff asked the Torrance County Sheriff's Office, here and after TCSO, whether they would be enforcing the mask mandate. The sheriff said, we're not going to enforce a mask mandate in the courtroom or anywhere else, okay? Court staff were harassed and threatened after this incident. On February 20, and just so everybody's clear for the record, I am against mask mandates. I think your personal medical decisions should be up to you. I don't think the state should be enforcing them on anybody. So when I say things like the courts of Arizona can, in fact, enforce the wearing of masks in their courtroom, it doesn't mean I agree with it. I want to be clear about that. It does not mean I agree with it, but they can do it. So court staff were harassed and threatened after this incident on February 28th, 2023. And why would Freeman harass and threaten court staff when it is an order of the New Mexico Supreme Court? That's weird. It's weird that they would harass the staff instead of the people who make the order, the people who issued the order. Weird, I know. On February 28th, 2023, the 7th Judicial Court entered an administrative order, hereinafter order, in the interest of safety and security of its judges, special commissioners, hearing officers, and other court personnel. See generally, administrative order entered February 28th, 2023, a copy of which is attached to plaintiff's complaint as Exhibit 1 and is incorporated herein by reference. We're on page 4 of 17. We're not getting there very fast, but I'll just go ahead and take their word for it. The order further explains that plaintiff is an obstinate visitor, is banned from the Torrance County District Court unless appearing for a hearing or having specific court business, and must be escorted by the Torrance County Sheriff's Office while in the building. When plaintiff sought to harass court staff at the courthouse in the 7th Judicial District, the court amended the order to include the courthouses in Torrance County, Catron County, Socorro County, and Sierra County. See generally amended administrative order entered March 23, 2023, a copy of which is attached to plaintiff's complaint as Exhibit 3 and is incorporated herein by reference. I know that, Nate. I got your text about it. And your text, almost verbatim, is exactly what you just put in chat. Do you need attention, Nate? Plaintiff again refused to comply with court orders. When the Torrance County court clerk asked plaintiff where his law enforcement was during one of his visits, plaintiff responded with hostility. Clerk, where is your escort? Plaintiff, my escort? Clerk, yes, by court order you're required to be escorted by law enforcement. Plaintiff says, an escort? Clerk, yes, sir. Plaintiff says, I don't know if you're aware, but prostitution is illegal in New Mexico. I don't know if you're trying to solicit me right now, but I don't appreciate it. As a matter of fact, I think I'll head over to the sheriff's department right right now and let them know that you're trying to solicit me. Is that what you're doing? Are you trying to be my escort? Witty! Due to plaintiff's continued refusal to follow court orders, the 7th Judicial District Court sent plaintiff a notice of order to show cause hearing filed June 7, 2023. On June 9, 2023, plaintiff filed his complaint for declaratory judgment and injunctive relief for civil rights violations, yada yada. The defendants recuse themselves from the state court proceeding, and the matter is pending in the 13th Judicial District Court. I didn't have any limits on here. Did I mistype something? No, no comment. James. On August 29, 2023, counsel for defendants served plaintiff's counsel a preservation letter asking plaintiff to preserve all evidence related to this matter. A copy is attached as Exhibit D. Where are the fucking exhibits? Where are the fucking exhibits? Ooh, ooh, ooh. So this apparently was sent on August 29th. Please be advised, retain, blah, blah, blah. Formal request your client to preserve not all of the following evidence. Any and all raw, unedited, and edited photographs, video recordings, yada yada. All post comments, messages, yada yada. Post comments, messages, yada yada. Notes, draft scripts, yada yada. Any and all articles, yada yada. A notice like this in federal court, it doesn't work in a state court, but it doesn't work in state court, or at least not in California, but this notice is effective. Now, $4.99. So they knew about this as of August 29th. Okay. And that's when was that notice of? There was a notice of appearance on August 15th. Okay. Okay. The following day, plaintiff admitted that he deleted some evidence. That's not good. They also sent. Oh, it's another YouTube video. Oh my God, he talked about it on a video. Oh Lord. Okay. They also sent something to my attorney saying they want me to preserve all of my journalistic materials for them so they can come and take those materials from me. They've said that they need me to preserve all my journalist materials because they intend to come and try to bully me. I don't recall seeing anything about bullying in that letter. But according to James, they're going to try to bully him and take those journalist materials from me, including any conversations, private conversations that I've had with confidential informants, because they know there are people, not just within their police departments and their legislature, but within the judicial system in New Mexico that are giving me information. They know it. It doesn't matter because I delete it all as soon as it's read, but they know, and they're going to try to bully anyone who would be giving me that information. Well, I mean, if as part of his standard practice he deletes it all, that's not a bad defense, you know. But anything from August 29th forward, he should preserve. Now, normally, like if the police or the state was trying to get information from a reporter about a confidential informant, um, that would they would have to like have a warrant or something. Uh, but since Springer is a party, they could just serve him the spoliation letter and they're good. See, James Freeman, I'm suing the court for rights violations, but they just gave me the offer of a lifetime. What's the offer of a lifetime? I don't know what offer of a lifetime he was given. Because a preliminary injunction is an extraordinary remedy, the right to relief must be clear and unequivocal. As such, party requesting, so basically, it has to appear on its face that they're going to win on the merits. It basically is the way it is. If you have a good enough case that you're going to get a preliminary injunction, you're probably going to win in the long run because the court's going to telegraph that. By the way, it looks like the requester is going to win. As such, the plaintiff requesting a preliminary injunction under FRCP 65 must establish 1. He will suffer irreparable injury unless the injunction continues. 2. The threatened injury outweighs whatever damage the proposed injunction may cause the opposing party. 3. The injunction, if issued, would not be adverse to the public interest. And 4. There's a substantial likelihood of success on the merits. Well, I think the state, or at least the judicial, at least the courts, win on 2 and 3. I don't think they lose on number 1 because he could still access the courts for his cases. And then there's substantial likelihood of success on the merits. I don't know which way that's going to fall out yet. But I'm going to say that 1 slightly, but not much, favors Freeman. 2 and 3 strongly favor the court. And then 4 is a toss-up. So easy money is, generally speaking, the court is not going to grant a preliminary injunction. That's the safe bet anyway. In relation to the case at hand, it is clear that none of these factors are met. Legal argument. Plaintiff's petition, as a matter of law, fails to meet the necessary requirements of a preliminary injunction. Interesting. A. Plaintiff's claim. So Kissacat says, why are people allowed to waste so much court time and resources? Well, it's not clear that this is a waste of time. Having read the initial petition, the petition made a very strong case, barring the opposition, which is why you always have to take these together. You can't just look at the petition. You have to look at the petition and then the opposition. But the petition presented a fairly strong case that I mean, if the facts alleged were true, and I can hear all the midwits going, "Facts are by definition true." Fucking midwits. But if the facts are true that Freeman alleged, then there was most likely a deprivation of his right to due process, among other things. So, I mean, this isn't necessarily a waste of time at this point. I don't know which way this one's going to shake out. Plaintiff's claim provides no suggestion plaintiffs, plural, will suffer. Was there more than one plaintiff? Hold on a second. It's one plaintiff. I don't know why they have plural. I don't know why they pluralized it. Plaintiff's claim provides no suggestion that plaintiffs will suffer irreparable injury. Someone's saying, I thought Springer won. No. Not according to Pacer. Dogs are playing. The party seeking injunctive relief must show that the injury complained of is of such imminence that there is a clear and present need for equitable relief to prevent irreparable harm. Preliminary injunctive relief does not remedy past harm, but protects plaintiffs from irreparable injury that will surely result without the injunction. Good. Sounds like World War III, but they're actually just playing. And fucking up my lawn, by the way. They're playing and they're fucking up my lawn. All right. Plaintiff has not identified the irreparable harm he faces. Instead, he points broadly to the First Amendment as if alleging constitutional violations is sufficient grounds for an injunction. In fact, an injunction is not a matter of right, but it may be granted only in the sound discretion of the court when the remedy at law is not adequate. So a remedy at law is money. If you're going to allege that you're going to lose money as a result of not getting a Siobhan, leave him alone. He's done. So if money will compensate you at all for the loss, then that's a remedy at law. Remedy at law is dollars. So if you're saying like, hey, if you don't give me this injunctive relief, I'm going to lose $500 a day for not being able to report on the happenings at the court and post it on my YouTube channel, then a remedy at law would actually make you whole because the court can issue an order that opposing party has to pay you $500 a day at the damages phase of the trial. So that's why they're talking about remedy of law. Remedy of law just means dollars make you whole. Dollars make you whole. Here, plaintiff exhibits no concern for the disruption. His refusal to follow court orders and rules has caused. Further, the court's definition of irreparable injury clearly does not coincide with the facts of this case. In fact, plaintiff's petition lacks in its entirety any claim suggesting that an irreparable harm has occurred or is likely to occur. That's true. But then again, that's just always betting odds are that a preliminary injunction will not be allowed, will not be granted. Plaintiff's claims provide no suggestion that threatened injury outweighs any damage the injunction might cause the defendants. That's true. He's gonna cause disruptions. Issuance of the injunction would be adverse to the public's interest. That's true. Some people don't want this was a family law courtroom that he was in, the one with Bennett. Bennett does, I think, DCSS, California calls it Department of Child Support Services. California, we use magistrates to do DCSS hearings. I think Bennett was doing those in like DVs, domestic violence cases. And believe it or not, I know it might sound crazy, but most people don't want these things recorded. Now, the standard answer to that, the standard response from the people who do want to record inside a courthouse is, well, but you're being recorded already. Well, the difference is that the recordings, the security recordings and things that the courtroom makes aren't, generally speaking, going to get broadcast all over the internet. Now, there has been a change, at least in California. A lot of hearings are broadcast. They are available. You can watch them. Like I know Sacramento, they have probate hearings that are broadcast on YouTube every day, or no, they use like some IBM service or something like that. Anyway, my point is that that things that aren't generally speaking going to be of a sensitive nature, like things involving like the family and domestic violence and things like that, are much more likely to be broadcast now than they were. But the at least when they're broadcast now, there is a court order saying that you can't disseminate it. So it's not like, in theory, it's not like it's just going to be out there floating, or have somebody with an axe to grind cut up your hearing to make you look bad or whatever. Plaintiff's claims fail to provide a substantial likelihood that plaintiff will prevail on the merits. Okay, the facts of this case clearly do not justify the issuance of a restraining order. Plaintiff has contemptuously disregarded the court rules and orders, harassed court staff, and disrupted court business. Further, plaintiff has deleted evidence relevant to this matter. It is evident that plaintiff has little to no regard for the judicial system, whether it be others' cases, or his own. As such, the issuance of a restraining order would be a waste of judicial resources and does not warrant an injunction for plaintiff. One thing I would like to point out is Bennett admitted the court was recording. There was a camera recording in the courtroom that he's required by, I think he said, statute to record. And I'm going to assume there are other cameras throughout the courthouse. That's an assumption. I'm making an ass out of you, and not me, but you. So I'm not entirely sure why they need Springer to turn over all the stuff that he's done. They have asked for a lot, like commentary and complaints, things like that. So that'll be interesting. Number two, the restriction of access was reasonable. Plaintiff refused and continues to refuse to comply with court rules of conduct. Plaintiff contends that defendant's order is unconstitutional because it impermissibly abridges the First Amendment. However, plaintiff fails to appreciate that while court hearings are open to the public, the court has rules. Specifically, the New Mexico courts has promulgated the following rules as relevant to this matter: video or audio recording devices. Now, before I go into this, Springer never, ever alleged in his petition that the rules against recording were unconstitutional. I'm on page 9. I'm going to go, and then I'm going to go and open that. And then I could go back here, and we're going to go back to the petition. And no one bought it yet. Do I have it? Do I have it? Appearances, a motion to dismiss. Those are hella old. Did someone send it to me? Because I had it. And if someone sent it to me, who? If someone sent it to me, I would give the person credit for it, but I don't divulge. I don't divulge. So these are solely for banning and excluding plaintiff. And it's not the general orders, it's the specific orders of Judge Murphy and Judge Murdoch-Poff excluding specifically plaintiff. The actions that they're talking about here are, again, the specific actions by the court against him, not their general orders. They don't talk about the general orders. So he's talking about they violated his freedoms when they entered the administrative order and the amended administrative order. But maybe they're just being extra careful, extra careful, because he has made a much larger prayer for relief. All right, so what's going on here? Okay. That. Yes, Frog did send it to me. He said it, and he sure did. Thank you very much, Frog. I do appreciate it. So the restriction of access was reasonable. Plaintiff contends defendant's order is unconstitutional because it impermissibly abridges the First Amendment. However, plaintiff fails to appreciate that while court hearings are open to the public, the court has rules. Specifically, the New Mexico courts have promulgated following rules as relevant to this matter. Video or audio recording devices, no photographic or audio-visual equipment of any type, including cameras, video or audio recorders or players, will be allowed without prior court approval. Cell phones. No person other than members of the judiciary, yada yada, shall be allowed to carry a cell phone into the courtroom, which is immediately contradicted by all cell phones must be turned off before entering the courtroom. So, do the judiciary attorneys, peace officers, and court staff have to turn off the cell phones? Because they're the only ones who are allowed to take cell phones into the courtroom. Any cell phone that rings or makes any audible sounds in a courtroom may be confiscated and held by security bail for any member of a district judge's staff. The cell phone will be returned upon payment of $25 dues. A district judge may impose additional sanctions for yada yada yada. Disruptive behavior will not be tolerated. New Mexico courtroom conduct, security, and attire. Open link in a new tab. Let's see what this says. All it says is disruptive behavior will not be tolerated. Well, that's useful. Spanx. Just wanted you to say my name. You'd have to give me a good dicking down for me to say your name. In addition, or vice versa, in addition to the rules for courtroom conduct listed above, during the January 27th, 2023 incident, the state of New Mexico had a mask mandate for its courtrooms in force. See Supreme Court of the State of New Mexico in the matter of the amendment, yada yada, available yada yada. The mask mandate remained in force until March 31st, 2023, yada yada. Nonetheless, plaintiff refused to comply with the court rules or the mask mandate. Plaintiff did not get court approval for video or audio recording. Plaintiff brought a cell phone into the courtroom and did not turn it off. Plaintiff was disrupted during a court proceeding. Plaintiff did not wear a mask into the courtroom and, when asked to do so, refused. Yep. Even after leaving the courtroom on January 27, 2023, plaintiff sought to return to the 7th Judicial District Courts without following any of the above stated rules and documented his noncompliance on his YouTube channel. Yep, sure did. In light of such persistent disregard for the court conduct, defendant's order was a reasonable restriction to ensure the safety of court staff as well as the administration of justice. Probably. The courthouse is not a traditional public forum. That is absolutely 100% true. In examining restrictions on these government institutions, the Supreme Court has held the government may exclude peaceful assembly or access which interferes with the function of the institution. See Adderley versus Florida, Greer v. Spock, U.S. Postal Service versus Greenberg, Civic Associations, and U.S. v. Grace. In examining such restrictions, the Supreme Court... Ooh, you know what I need to do? I need to turn on live chat. Oh, there is no moderation activity. Wow, look at all that shit people were hiding. Did he need permission to submit this? I don't know if we're talking about the. Hold on, what the? We're talking about the same thing. This was submitted by the New Mexico defendants in Springer. In examining such restrictions, the Supreme Court has used an analysis based on the place in question. Is it a traditional public forum? Under this lens, the Supreme Court has found that restriction of access was reasonable for the jail, Adderley, the military base Greer, and the letterboxes Greenberg, because they were not public forums. The fact that did he leave? Oh, that sucks. I did not kick him. The fact that the public is generally allowed access does not transform a place owned or operated by the government into a public forum. The test here is not whether the courthouse is appropriate for visitor or for video recordings, but whether the character of the place is appropriate for the expression of views and ideas generally. I don't know if you guys can hear that. We have guinea fowl now, and they make a lot of noise. We have 4 of them. And if you thought roosters were bad, if you thought chickens were bad, those guinea fowl just make noise. It's crazy how loud they are. The fact that the jail grounds in Adderley may have been an appropriate place to assemble to protest the arrest of students, racial segregation at the jail, but that did not make it a public forum. Conversely, streets and parks are traditional public forums. The 7th Judicial District Courthouse is more similar to the jail considered in Adderley, the military base considered in Greer, and the letterboxes considered in Greenberg. In examining restrictions on these government institutions, the Supreme Court has held that the government may exclude peaceful assembly or access which interferes with the function of the institution. In this context, the restriction only needs to be reasonable and content neutral. So, like the restriction against filming in the courthouse would most likely be reasonable and content neutral. Adderley's held that the government may, in non-public forum situations, reasonably limit access to government places. The United States Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purpose. Man, how many times have I quoted that? Here, the 7th Judicial District Court's restriction and order limiting plaintiffs' cases to the courthouse for its own hearings or official court business and without law enforcement escort is reasonable. Again, I don't think that's the appropriate standard. Because this is a trespass. This is a trespass. I don't know why we're looking at. I don't know why we're doing a First Amendment analysis on what is, for all intents and purposes, a trespass. Kind of weird, but okay. The state, no less than an owner of private property, has power to preserve yada yada. The restriction is content neutral, as its purpose is to ensure the compliance with rules for court conduct. That sentence, especially with the double period, makes no sense. The restriction is content neutral, as its purpose is to ensure the compliance with rules for court conduct. That's a non sequitur, but okay. Even now, plaintiff refuses to follow court rules of conduct. Further, in imposing the restriction, the 7th Judicial District was ensuring the safety of its court staff who have been needlessly harassed. Is it really a safety concern, though? Like, is it a safety concern? I don't think it's a safety concern. I think it goes to like the functioning of the court system and all that stuff. But safety? I don't think he threatened anybody with physical harm. The Torrance County District Court had to go on lockdown due to the threats to its staff. Why didn't these threats make it into this particular pleading? I haven't seen any threats make it into this pleading. Where is the declaration that or other attachment that shows these particular threats? Defendants were and are protecting its courtroom staffs and litigants. Oh, Well, God bless him. Nonetheless, plaintiff makes light of the seriousness of his conduct and persists in his harassment. Accordingly, the restrictions on plaintiff were reasonable. That was a pretty shit argument, but okay. Plaintiff is not a member of the press. Mm, mm. I'm gonna beg to disagree. I'm gonna beg to differ. I think he is. I know people don't like it. I know people get all mad. There was a ruling in the Supreme Court of the state of Washington that YouTubers aren't press. They misunderstand the decision when they talk about it. It doesn't say that, but yeah, Springer is a member of the press, definitely. And even if he were, the First Amendment does not grant him a special right of access to gather information above and beyond that of the public. That's also a true statement. So the first part is not a true statement, but this part is a true statement. Plaintiff asserts that he is a member of the press, and therefore the order offends the First Amendment. Well, the First Amendment is the right of the people to gather news and information and to report on it. And there's a reason why trials are open to the public. You have the right, a Sixth Amendment right, to a public trial. I think it's the Sixth Amendment. Anyway, the reason those two go hand in hand is the public trial allows the people to monitor the situation, the trial, to make sure that the trial is fair, and then they can report on it if it's not. So those two go hand in hand. He argues that his right to gather news was impermissibly abridged. I don't think it was impermissibly abridged. If he got notice, I still think that the issue is the notice. Did Springer have notice of these orders? Did he have notice and an opportunity to be heard before these orders were issued against him? That's what I think is going to be the issue. But yes, Unforgiven Jerry, everybody's part of the press. Freedom of the press is misunderstood because people think that it means specifically like the corporate press. It doesn't. Freedom of the press is your right to print. You know, you got to remember that Benjamin Franklin had a printing press, and he would print off. I don't know if he had it specifically, but he printed off pamphlets and things like that. He was a member of the press. He didn't work for CNN or MSNBC or anything like that. He was a guy who published stuff. Springer's a guy who publishes stuff. Now, you might not think of Springer as having the same gravitas as Benjamin Franklin, but they both do the same thing. Benjamin Franklin was accused of being a rabble-rouser himself. You guys might not like it, but that's the fucking truth. Defendants note that plaintiff has not held himself out as a member of the press to court staff, nor followed the procedures promulgated by the New Mexico courts for the press. See, right there, they went to the corporate press. Notably, at the January 27th, 2023 hearing, plaintiff snuck in his cell phone to video record without court approval and refused to identify himself when asked by an officer of the court. Like, what does that fucking matter? What does that mean? So let me just understand their logic. Let's unpack it a little bit. That's like saying that Veritas isn't a press organization, or the organization formerly known as Veritas. What their MO was is they would have people surreptitiously record in situations, and they would not identify themselves as the press. Imagine how stupid it would be if you could not be considered a member of the press unless you openly recorded and unless you identified yourself immediately as press if ever asked. This is like the same thing that people on the opposite side of the fence have about, officers have to identify themselves if they're undercover. So all you have to do if you're buying drugs from somebody is ask them if they're a cop. If they're a cop, they have to tell you. And no, they don't, because cops can lie. Well, reporters can also lie. The press can also lie. The press can record you surreptitiously. Cops can record you surreptitiously. I mean, there might be some law that they're violating, or a court order, like a law against eavesdropping or whatever, a court order against recording in a courtroom, but they still do it. I mean, that is literally what they do. Sergeant Rock says Veritas is legitimately fake news. Sergeant Rock, you're a fucking idiot. They take recordings of people talking and being recorded without knowing that they're being recorded, and they post them. You're a fucking idiot, Sergeant Rock. And I've said that before, and you have never impressed me as being anything other than a fucking idiot. Brazos asks, if courts and government buildings can ban firearms as per Heller, why not cameras and cell phones? Well, there are different things there are different amendments that have been interpreted differently. You have the scrutiny analysis in the First Amendment. You have more of the historical analysis of Heller. So they're different amendments that have been treated differently. So you can't just analogize them one to one. Henry Walsh's Project Veritas is a bad take, as they were scum. See, it's not the truth of what they say that matters to Henry. It's that they were scum. You know, they could be absolutely telling the truth, but they're scum because they misrepresented that they recorded. They manipulated the people into saying things that they wouldn't have said had they not known. Well, Henry, you're also a fucking idiot. You're also a fucking idiot, and you probably believe the news. Jesus fucking Christ. My God, why do stupid people watch my channel? It just really irritates me. Unsub, go away. Take your shit tier bias takes elsewhere. Speaking of bias, here's a fun little story, or a fun little prediction. They twist the recordings. Ugh. Show me the lawsuit where they get sued for defamation and they lose. Show it to me, Sergeant Rock. You fucking idiot. Hard sympathy for Veritas. No, I'm not. If it's right, it's right. If it's wrong, it's wrong. They're taking literally what people said. Oh, that's not what I said, but thanks. I literally read your post out loud verbatim, Henry. You fucking tool bag. You fucking tool bag. But anyway, here's my prediction. Speaking of tool bags, Frauditor Wrangler is most likely going to keep a substantial portion of his audience. He's been outed as a complete fraud, but he will 100% retain a sizable chunk of his audience. Veritas undisputedly lied on the fetus body part selling video, that specific video. You can say they didn't, but you're wrong. Show me the defamation lawsuit where they lose. Show me where it's proven undisputably, and then maybe we'll talk. But to the best of my knowledge, Veritas has been sued a lot of times by a lot of people, and they haven't lost. So, eat a bag of dicks. Like, people like, oh, you're simping for Veritas. No, I'm not. I don't fucking care. I don't like them. I don't follow them. But truth is truth, and reality is reality. Again, Paige, show me. They were sued a lot of times. Show me where they lost. They've been sued a lot of times, and show me where they lost. Because they spent a lot of money on defense, but they didn't lose. They didn't lose. Fucking idiots. I am surrounded by idiots. Politics. Politics. Veritas. Oh, those guys are on the red. They're red side, right? They're Republican, I think. Something like that. I don't really fucking care. You're sipping for them. You're one of those Republican guys. I am still a fucking monarchist. I believe in a monarchy. We should have a king. God damn it. We should have a king. Because our current form of government sucks ass. So does just about every other form out there. And so, no, I'm not red side or blue side. I want a fucking king. How about that? Ooh, my red side, my blue side. The only truth Veritas has is in the name. I'm still going to hang out. I'm just going to say the stupid shit with nothing to back it up. Show me the fucking lawsuit, Sergeant Rock. You tool bag. You fucking tool bag. My God, I loathe people like you. You're biased, and all you do is just spit out your bias. and you ignore all the shit that you don't like. There's a lot of people I don't fucking like. And if you're right, you're right. If you're wrong, you're wrong. Whether I like you or don't like you. If you're right, you're right. If you're wrong, you're wrong. Whether I like you or I don't like you. All right. Anyway, let's get back to this. Enough of entertaining the fucking idiots in the chat. There can be no doubt that freedom of the press is extremely important and necessary in our democratic form of government. We are a republic form of government. The states are required to be republics. So you're a fucking idiot. Freedom of the press necessarily involves two things: acquisition of information and dissemination of information. See this particular Harvard Law Review from 1974. It probably hasn't been updated to reflect current cases. Freedom of the press is a very broad concept. Here is a narrow issue. And you know they're you're a douchebag. Well, and you are gone. Have a nice day. Thanks for watching. So you know they don't have anything really to support it when they're citing a Harvard Law Review article from 1974. Freedom of the press is a very broad concept. Here's a narrow issue: the right of access by the press or public to an area controlled by the government for an indeterminate purpose. The Supreme Court has rejected the argument the First Amendment requires that members of the press be given special access to areas controlled by the government. That is correct. In Pell versus Procunier, members of the press sought to strike down on First Amendment grounds the California Department of Corrections manual provision, which provided that press and other media interviews with specific individual inmates will not be permitted. In holding that the First Amendment does not require that members of the press have a special right of access to gather information above and beyond that of the public generally, the court examined the governmental interest behind the regulation and the right of access allowed to prison. The court noted the regulation was not a part of an attempt to conceal conditions in the prison or frustrate the ability of the press to report on those conditions. As discussed above, the defendant's restriction is aimed at protecting its operations, staff, and litigants, not at concealing the judicial system. That is true. I thought there was a KTVU one. Supreme Court case KTVU. Access to prison. Oh man, I thought there was another one that involved KTVU. Mm-hmm. I'm remembering another one. Damn it. I don't remember it clear enough, apparently. Where were we? All right. Plaintiffs spoliation of evidence maliciously. Here we go. KMB says Project Veritas lost a lawsuit in a jury verdict for heavily editing video footage of a political consulting firm last year and were ordered to pay $120K. However, I don't know if it's in appeals. So one where somebody, thank you, KMB, actually provided something to back it up, where they edited video footage of a political consulting firm last year and were ordered to pay $120K. Nice. Well, one out of a lot. My dog is howling in sympathy with your dog, says Script Cat. Well, they weren't howling, they were tussling. But right now we're dealing with plaintiff's spoliation of evidence maliciously impedes defendant's ability to defend and litigate this matter. Spoliation and defendants. Now, I think Microsoft Word doesn't. excuse me, doesn't spell check all caps. Mr. Showbar says King Charles, enough said. I'm not suggesting King Charles is by definition of the best king by any stretch of the imagination, and the monarchy in the United Kingdom is titular only. They have no actual power over anything. So, let's get on with it. I don't know if I want to get on with it. I want to talk about kings. But anyway, uh, there have been amazing kings in history, and there have been terrible kings in history, but there have never been amazing republics in history. Uh, they always go downhill super quick, just like the U.S. did from the very get-go. While the duty to preserve evidence is often triggered by the filing of a lawsuit, this duty may arise earlier if a party knows or should have known that the material may be relevant to future litigation. That is true. Springer filed this, so he probably should have started saving evidence when he decided to file this. That is, if they make that point, it will be a good point. In determining whether a party's duty to preserve has been triggered, courts evaluate facts such as the likelihood that a certain kind of incident will result in litigation. Ultimately, a party's duty to preserve arises when it has notice that the documents might be relevant to a reasonably defined future litigation. The court's decision as to when a party was on notice must be guided by the particular facts of each case. Once it is established that a party's duty to preserve has been triggered, the inquiry into whether a party has honored its obligation to preserve evidence turns on reasonableness, which must be considered in the context of whether what was done or not done was proportional to the case and consistent with the clearly established applicable rankings. Here, plaintiff had sufficient notice of potential litigation because he is a party who initiated the lawsuit. That's a great point. What evidence did he not save? He didn't save all the videos that he recorded of the encounters inside the court. He didn't save all the communications he had with people about it. He didn't save the comments that he received on them, etc. That was the stuff in this one right here. He didn't save all of these things: raw, unedited, and edited photographs, video recordings, recorded audio, computer media, measurements, real evidence, documents, materials, and all other evidence and things related to Mr. Springer's YouTube channels and social media accounts which were presently in his possession or in the possession of his aliases, businesses, employees, or agents, any and all posts, comments, and messages by Mr. Springer's social media accounts / platforms, including but not limited to his YouTube channels, Instagram, Facebook, TikTok, etc. These are all the things that he was supposed to say. Basically, everything involving his social media and any photographs, video recordings, audio recordings, etc. That's what he was supposed to save. Therefore, he should have ensured the maintenance of his raw videos, edited videos, notes, and other potential evidence. That is true. Defendants listed evidence plaintiffs should preserve. They did it a long time after he filed, though, because he filed in June 9th is when he filed. And they didn't notify him until August 29th. However, plaintiff publicly admits to spoliation the day after his counsel is served with a preservation letter. He did. He sure did. The near immediate timing of plaintiff's spoliation conduct demonstrates intentionality and further underscores plaintiff's disregard for the judicial system. I don't think it does. Because he said that was his habit, essentially. It is difficult for defendants to adequately gather information to defend this case when the plaintiff engages in such egregious behavior. And then they have their affirmative defenses, and I don't really care about them. Reservation of rights, conclusion. All right. So that was Springer versus the 7th Judicial Court. We're going to see where that goes. Next, I think we'll do Decastro. All right. Decastro. So first thing, we have the opposition to Chili's motion for reconsideration. Procedural facts in this case have been thoroughly briefed. Plaintiff filed the present motions for reconsideration, requested court reconsider the order. He is attempting to relitigate issues previously considered. That is true. Oh, Aaron Queen is feeling a little upset. Poor Aaron. It's okay, buddy. It's okay. The only way you're going to change the court system is to either vote out the judges in the Supreme Court down there, or overturn the Constitution of New Mexico. One of the two ways. All right, standard of review. Though the federal rules of civil procedure do not expressly provide for motions for reconsideration, 59E permits parties to alter amended judgment within 20 days. They serve a limited function. There has to be clear error of law, newly discovered evidence, an intervening change in controlling constitutional law, or to prevent manifest injustice. The clear error of law is the wholesale disregard, misapplication, or failure to recognize controlling precedent. And this clear error would have to be done by the trial court, by the court that dismissed the case or whatever. Motions for reconsideration are not intended to relitigate issues. That is true. It must not be used to relitigate all matters or to raise arguments or present evidence that could have been raised prior to the entry of judgment. That's going to be a problem for him because he could have this is the city or the county? City. So the city is a 12B6. So he could have raised. Well, I don't know if he could have done those. I think he had to amend his complaint either way. Moreover, a motion for reconsideration does not provide plaintiff an opportunity to try out new legal theories or submit new evidence previously available to it. That's correct. The court will not find clear error of law when the moving party claims the court misinterpreted or omitted key facts. That's a nice one. It's a nice one. And it's Southern District. It's Southern District, so they will probably follow along with what the Southern District of Ohio will probably continue to do what the Southern District of Ohio has previously done. Courts disfavor motions for reconsideration because they consume a court's scarce time for attention to a matter that has already been decided. In this case, he fails to argue reconsideration is necessary on the basis of 1, an intervening change of control law, 2, new evidence not previously available, 3, need to correct clear error, or 4, prevent manifest injustice. Rather, he's seeking reconsideration from this court because he does not agree with the court's decision. Additionally, plaintiff seeks to offer new theories of law, an argument not previously made. However, motions for reconsideration are aimed at reconsideration, not initial consideration. Additionally, or accordingly, plaintiff's motion for reconsideration must be denied. They have probable cause for his arrest. I think we agreed with that. We need to go over that. First Amendment retaliation fails as a matter of law in Neves versus Bartlett. Yup. Plaintiff attempts to distinguish the present law with case law cited by this court, arguing that those cases involve summary judgment motions where a showing of evidence is appropriate, and that requiring a showing of evidence at the stage in the pleading is inappropriate. However, based on the pleadings and video recordings plaintiff attached thereto, the court determined it was clearly established that the material issues of facts remained to be resolved, and therefore the Arrington defense were entitled to judgment as a matter of law. That is, Chili just doesn't understand that the shit he does is not exonerating on him. It is very much damning of him. In Wesley versus Campbell, the court held the plaintiff's false arrest claim was incorrectly held to a higher pleading standard, calling for a substantial showing rather than what was required under 12b6, and was wrongfully dismissed by the lower court. The Sixth Circuit identified the proper standard for surviving motion to dismiss in that a plaintiff must show, quote, more than a sheer possibility that a defendant acted unlawfully. Plaintiff states that he is only required to plead facts and not make legal conclusions, but he has failed to assert any facts supporting the lack of probable cause and has, instead, been admissions to the contrary. Quote, although the court must accept well-pleaded factual allegations of the complaint as true for purposes of a motion to dismiss, the court is not bound to accept as true a legal conclusion couched as a factual allegation. That is true. And that is exactly what I was saying that he was doing with all of his facts, in quotes. Further, as this court noted, even when the facts as set forth in the amended complaint were taken as true, a motion for judgment on the pleadings may be granted if the moving party is nonetheless clearly entitled to a judgment. Plaintiff's, quote, belief, end quote, that he was arrested out of retaliation is irrelevant, regardless of his belief and or any alleged evidence he argues will come out during discovery phase regarding a particular officer's state of mind. As a matter of law, the Ironton defendants had probable cause, and thus, by law, his claim fails. I believe that is correct. Again, as this court has pointed out, plaintiff has failed to point to any legal authority that the officers in this case should have escorted him off the property instead of arresting him. Plaintiff has failed to acknowledge facts demonstrating he had any privilege to remain at the Ironton City Center after closing or that there was retaliation. As such, this court properly determined there was no basis for his claim of retaliatory arrest. He was provided an adequate state remedy. That was the replevin action, yes. Court properly exercises jurisdiction. The decision to grant or deny. Courts have discretion to allow plaintiff the opportunity to amend their pleadings. The decision to grant or deny a plaintiff leave to amend his complaint pursuant to Rule 15a is committed to the district court's sound discretion. Although Rule 15a provides that leave to amend shall be freely given when justice so requires, the district court may deny leave to amend in cases of bad faith, dilatory motive, or undue prejudice to the opposing party. In fact, this court provided plaintiff with such an opportunity. As outlined above, after he filed his complaint, Ironton defendants filed their first motion for judgment on pleadings. Plaintiff failed to respond. This court issued show cause orders and ultimately exercised its discretion to allow plaintiff to either respond to Ironton defendants' motion or to file an amended complaint. Plaintiff elected to file an amended complaint. Plaintiff was on notice as to any deficiencies in his complaint based on the Ironton defendants' initial motion for judgment. In response to this court's show cause orders, plaintiff stated he was, quote, committed to prosecuting this litigation and in anticipation of any defense's response, and has been working diligently to amend his complaint. However, based on the undisputed facts, plaintiff was unable to plead any additional facts to cure his deficiencies, and thus a further amendment would have been futile. Again, because plaintiff fails to argue that this court should reconsider the claim under any of the proper bases allowed by established by case law, his request for consideration must be denied. That is a fairly solid pleading. So good job to them. But wait, there's more. So we have a miscellaneous relief. What we have here. A motion to vacate judgment and leave to file second amended complaint. Yada, 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 under FRCP 59 and 60, due to new evidence and errors raised in plaintiff's motion for consideration. Points and authorities, yada, yada. File first amended complaint, yada, yada. All right. Points and authorities. To support it, a plaintiff must set forth facts when construed favorably. One, establish the deprivation of rights secured by constitutional laws of the United States as by a person acting under color of law. Plaintiff is only required to plead the facts, not to make legal conclusions. They just fucking address this. I still don't think Chile understands what a fact is. Plaintiff did plead and did include video evidence of him entering a traditionally public forum. So that's a legal conclusion. That's not a fact. A fact would be he entered the Civic Center, I think it was. A legal conclusion would be that the Civic Center is a traditional public forum. I strongly doubt the court is going to find that a Civic Center is a traditional public forum, or it's not a Civic Center, they called it the City Center, that's what it was. Get Stout on here. Stout will tell you instantly, without even thinking about it, that it's a limited public forum. Now, whether Stout's right or not, I don't know. To exercise his First Amendment rights, he was denied a permit and arrested as a result. He was arrested as a result of being denied a permit. Interesting. And that, see, again, he was. This is a legal conclusion. He was denied a permit. That's a fact. He was arrested as a result. That is a legal conclusion. He was arrested as a result is a legal conclusion. And that this is a policy of the policing organization, either due to a written policy or failure to train. Plaintiff further alleges, based on information and belief, that his arrest was retaliatory for his exercising his rights, and that evidence of retaliation, yada, yada, yada. Jesus, Chili, you suck at writing. Moreover, plaintiff's rights were chilled. Even where a pro se plaintiff leaves out facts, his complaint must only be dismissed where, if allowed, he would prove no set of facts which would entitle him to relief. I don't think that Chili can plead a set of facts that would entitle him to relief. Well, had he not pled the facts in his original complaint and his follow-up complaint, and had he not essentially made the video of the arrest part of the complaint by referencing it in the complaint, he might have more freedom to actually plead facts which would entitle him to relief. They wouldn't be true, but he could probably allege facts that, if true, would have entitled him to relief. But he's really hemmed in now. He's cornered. Besides the claims raised, plaintiff has likely also stated facts. He's likely, this, could have, maybe did, maybe didn't. Who the fuck knows? Chili certainly doesn't know. Here, quote, defendants ostensibly arrested plaintiff for violating Ohio's criminal trespass law. However, if instead, as plaintiff appears to allege, defendants arrested him because of the content of the speech, the defendants acted in violation of the First Amendment in ways that should be clear to a reasonable officer. I have to take a slight dip for, how do I do this? I can do this. Aha! I'm going to take a slight dip. I'm going to grab myself something to drink and turn off the sprinkler, and I will be right back. Enjoy the sounds of the country while you wait. Country. Did everybody miss me? Oh, yeah. Hell yeah, brother. Hell yeah. Chili's humping grounds. Nice. I like Chili's humping grounds. All right. Here, the court should have found that plaintiff could plead a set of facts to make a valid claim. Quote, defendants ostensibly arrested plaintiff for violating Ohio's criminal trespass law. However, if, as plaintiff appears to allege, defendants arrested him because of the content of his speech, then defendants acted in violation of the First Amendment. All right, well, let's check it out. Inspect what you expect. Watson versus Haynes. Okay. Pro-life movement. He was on it. Sidewalk counseling. He alleges he never threatened. Plaintiff admits he crossed property line. He's been charged with and convicted of criminal trespass in the past. Claims that he's always treated judge and prosecutor's respects, or sense with dignity, yada yada. His regular presence, yada yada. So he walked onto CWS property and took back his sign from Jackson because she was going to destroy his sign. Okay. All right. So what is the difference? What is the difference between a case like this, where someone takes your sign and off a fence where it's allowed to be, and then standing on their property, start to destroy the sign, at which point you enter their property to stop them from destroying your property? What's the difference between that and, I don't know, being in a town hall, city hall, after the city hall closes? What's the difference? And here you go. He found that plaintiff was privileged to enter. The court found that he was privileged to enter to retrieve his sign. Huh, crazy that. What's the difference? So, in this case, in this particular case, Logsdon versus Haynes, he had a privilege to enter onto the property. What that means is that there was a legal right for him to enter onto the property for a specific purpose. Chile did not have privilege, and that's a problem for him. So, in ways it should have been clear to a reasonable officer, in the Logsdon case, a reasonable officer would have listened to the witness and have heard the witness say that he entered the property to retrieve his sign that the other person was destroying. So there is a qualitative and quantitative difference between what Chile has alleged and can allege and what was alleged in Logsdon. Leave to amend. When a motion to dismiss a complaint is granted, courts typically permit the losing party leave to amend. Plaintiff requests leave to amend prior to dismissal at opposition number 39. A district court should normally grant a pro se plaintiff leave to amend where the plaintiff could possibly cure the pleading defects by pleading additional facts, even where the plaintiff has not requested leave to amend. Stating C. Brown versus Matuzik, say that generally, if it is all possible for a party against whom I have not read that one. All right. If it is at all possible that a party against whom the dismissal is directed can correct the defect of the pleading or say a claim for relief, the court should dismiss with leave to amend. Okay. I just don't think that he has the ability to amend it. He's locked in. The video of the arrest is damning. I don't know what he can do. Like, I'm not trying to be a dick. Obviously, I try to be fair. I try to look at the facts and make my determination based on the facts, not on my particular bias for or against someone. I don't see Chili prevailing on this. The video shows him being there after it was closed. He was. They said he was closed. They said it was closed. He stayed there. The police came and said, like, bro, you got to go. And he's like, no. And then they arrest him. Like, I don't even understand what argument he could possibly make, what facts he could possibly allege, consistent with the video, that would at all entitle him to any sort of monetary relief or even injunctive relief. New evidence. New evidence is one of the grounds for amending the complaint. Okay? This is where you would normally put a citation, but that's fine. While working on a new complaint, plaintiff's newly hired forensic experts discovered he has forensic experts, plural. They discovered it just today. That's fucking convenient. His newly hired forensic expert yesterday discovered yesterday. When was this filed? Was this filed today? So yesterday, that the plaintiff's newly hired forensic experts discovered yesterday that the times of the events were incorrect in the original and First Amendment complaint. Since plaintiff's video of the arrest of streamed live to YouTube, plaintiff could rely on YouTube's atomic clocks instead of the wall clock on the City Hall in the frame of the video. We have a lot of problems here. There was an attachment, right? It's a Second Amendment complaint. I'm on page 6. So there's no declaration of these experts. That's problem number 1. Problem number 2 is normally you'd have to authenticate like why YouTube's atomic clocks. I mean, it sounds great and all, but you'd have to authenticate why they were more accurate than the wall clock in the City Hall. That's problem number 2. Problem number 3 is that so the city employees thought it was closing time, number 1. Chili, at the time of the arrest, thought it was closing time, number 2. And the police thought it was closed based on the representations of City Hall and probably looking at the clock themselves. So did the police have probable cause to arrest him at that time, regardless of whether or not City Hall should technically have still been open or not? And it does not matter if the police were using the clock at City Hall to determine closing time, right? No, the police didn't determine the closing time. The city employees said we're closed, but did they have probable cause? With what the police knew at the time, with the wall clock, with the City Hall employee saying that we're closed, with Chili still being there, did the police at that point in time, could they say that a crime was probably being committed and that Chili probably was committing the crime? Yes, they still could. I mean, maybe if Chili manages to drag these experts out to Ohio and authenticate them not authenticate them, but actually have them establish their expertise and have them actually authenticate that the YouTube's atomic clocks are somehow uh, more reliable, or that they on the date and time of the video that um, that somehow it would show that City Hall should have been open, then maybe, not definitely, but maybe Chili would have an argument that he was not trespassing and that he therefore was not guilty of a crime. But that does nothing. That it does nothing to change whether or not the police had probable cause. Chili's guilt is not at issue in this particular case because this is a civil case, but it's whether the police had probable cause that a crime was probably being committed and that Chili was probably the one committing the crime. K&B says Chili wasn't arguing on video that he had 1 minute left before closing. He was telling everyone that he was staying as a form of protest. But again, that doesn't matter. What matters is, did the cops have probable cause? That's it. If they had probable cause, arrest was valid. If they didn't have probable cause, well, then there's something. This new evidence showed the clock in City Hall was fast, and the plaintiff was arrested for trespass while the City Hall was not only open to the public, but also before its regular closing hours. Plaintiff could not have reasonably determined this, as plaintiff is not an expert, and plaintiff could not have been expected to hire an expert prior to discovery, if at all. It is routine to hire experts not only before discovery, but before you even file the fucking case. For example, I have never done this, but for one of the law firms that I work for every personal injury case, the very first thing that attorney does is he hires an expert to review the medical records. Not personal injury, excuse me, medical malpractice. The very first thing he does is he hires an expert to review the medical records. And part of that review is that medical expert is going to give a report, an opinion on whether or not there was a breach in the standard of care, and if so, how much that's worth. Like if it's going to cost $100,000 for surgery to fix this particular issue or whatever, if it even can be fixed. So it is routine. It's commonplace for a case that's involving damages or based on emotional distress. Very first thing, you send your client to a psychologist to treat your client and also render a report, and you're going to use that report eventually in the litigation. So you start the fuck off with experts 9 times out of 10. But let's just fucking assume that Chili actually hired experts. Now, I don't believe it for a minute, but let's just assume, arguendo, that Chili hired experts to review this footage and to determine what YouTube's atomic clocks say the time was when this was being streamed. And then did something to verify that those atomic clocks were somehow more accurate than the wall clock at City Hall. And that it showed when you're in the country and the dogs are put away and something is rustling in the grass right next to you, that's a weird feeling. But it's gone now. But it's a weird feeling. Anyway, if you believe, this is so far Like, who would even think to hire an expert to check YouTube's atomic clocks? Staffo Flag says, according to the U.S. Supreme Court, I always kind of stiffen up a little bit when I see people saying that, because normally I like to know which case. But Staffo Flag says, according to the Supreme Court, probable cause exists when, quote, facts and circumstances, end quote, that police officers know about based on, quote, reasonably trustworthy information are sufficient. Yeah. Yeah. I could understand the Supreme Court saying that because that is probably a correct and accurate quote. But yeah, it's based on what they know. Like, would they think that a crime was probably being committed? Yeah, they look up at the clock. It's 5:03. Um, they know that the city employee has announced that the city hall is closed, and there's this jackass, and they're like, "Hey, jackass, you got to leave. We're here because city employees gave you warning that you had to leave, and you didn't leave, and the jackass is still there." So, based on what the cops know, yeah. Additionally, defendants had this exculpatory evidence but never provided it to plaintiff in violation of criminal procedure for the related criminal case. So now his accusation is that the defendants hired experts to determine what the YouTube atomic clocks were reading at the time when Chili was arrested. I'm going to go with no, they fucking didn't, and you're fucking stupid. The prior judgment was therefore obtained by fraud. The prior judgment was therefore obtained by fraud. Okay, all right, let's unpack this one. So, who would have exculpatory evidence in the criminal procedure? Well, the prosecution would have the exculpatory evidence in the criminal procedure. The prosecution would. And they have a obligation, a Brady obligation. I forget the name, the rest of the case, but it's a Brady violation if they don't give you exculpatory evidence. But the prosecution has it. Not the city, not the police, not the county, the prosecution. The prosecutor's department would have any exculpatory information. Chili did not sue the prosecutor. The prosecutor would have immunity anyway, qualified immunity. But no, the prior judgment was not obtained by fraud. And also, there was no duty in the civil case, even if he had sued someone with this information. Let's just assume that he had sued someone with this information. This never got to the discovery phase. They never had their discovery meeting where they have to come up with a discovery plan and exchange preliminary disclosures and all that other stuff. So, what fraud, dude? They had, in the civil case, they had no obligation to disclose any of this stuff yet. And it was Chili who fucking filed a motion for protective order to not have discovery. Newly discovered evidence is good cause for allowing even a late amended complaint. Even if Chili amends his complaint to include that, it will do nothing for him. People will laugh at him. I will laugh at him. This new evidence would lead a reasonable juror to find plaintiff innocent of the trespass charges, which this court ruled on. This court did not rule on whether or not Chili had actually trespassed. The criminal court will eventually, if Chili ever shows up in Ohio and goes to court on the criminal charges, The criminal court will rule on the trespass charges, not this court. This court is not at all ruling on the trespass charges. I think it's this one. Guilty. Oops, TY. Nope. So trespass is mentioned exactly once. Exactly once. So the court could not have said that Chile is guilty of trespass. Consent under local rule 7.3. Plaintiff contact opposing counsel who will be opposing this motion. Well, I would bet they will. All right. Well, let's do this one then. Let's see how retarded this is. 48 motherfucking pages. You've got to be shitting me. Who is this fucking idiot? Oh, fuck me. All right, we're going to go through this fairly abruptly. Hey, he repled against the county and the sheriffs. That's great. Sorry, I'm looking for where he actually gets to. All this background stuff is fucking garbage. I interviewed someone who said something. Well, great. Here we go. Unlawful arrest. All right. At 3:05 p.m., I entered yada yada. Less than a minute later, I inquired about the common area, blah blah blah. Crambit's office. Inquired about rain. Get piece of paper. Had to approve the request. I'd be around. I was then giving conflicting information that Cramblett had to approve the request. I don't know what the fucking conflicting information is. It asks, I thought there was a page limit on these submissions. No, your complaint can be as long as you want it to be. There's not a lot of return. I mean, if you need 48 pages to allege facts sufficient to state a claim, then there's your sign. That's all I'm saying. That's all I'm saying. I saw a sign, proud supporter of IPD. I exited 321, 420, 420. All right, 458. At 4:58 p.m. now, the lights were turned off. At 4:59, they entered, followed by 5. I started filming them. At 4:59 p.m. and 32 seconds, she says to cease and desist your disorderly conduct, or you'll be arrested. What, vacate or you will be arrested. It was 4:59 and 44 seconds now when she finished saying this. Oh, nice. Nice. I did not feel free to leave. He left a lot of the same bullshit in there. Whether or not you feel free to leave. Were you free to leave? She's literally telling you to leave. And he's like, I didn't feel free to leave. She's telling you to leave. But I didn't feel free to leave. But she's telling you to leave. But I didn't feel free to leave. It's like, why'd you rape her? Oh, well, I didn't feel like I could stop. She told you to stop. But I didn't feel free to stop. I mean, I really felt like I had to continue. Dude, she said to stop raping her. But I didn't feel like I could stop. I felt compelled to finish. Okay. I'm more than willing to go with you. I said I'm more than willing to go with you, and then started to repeat herself. Jose M. Before she realized what I said, she said, "You will," and then motioned with the figure. She said, "Let's go." So here he admits that the wall clock is what he was using. Well, that's probably what they were using too. The timestamps on YouTube metadata are expected to be accurate within a few nanoseconds. That doesn't mean they are. They're just expected to be. It's powered by Jailer. Abuse of power by Jailer. All right. Well, let's just glance through it. Social security number. Felony obstruction. Again, this is already this has literally already been found by the court to be insufficient. Like, I don't even know why you're talking about it. I'm going to go out on a limb here and suggest that with this exhibit 1 through 4 with a manual thumb drive and attachment 1 titled exhibit. Oof. Did he really? Did he fucking really? This is a demand for return of property. He fucking submitted the video again. He submitted the video again. Like, yeah, like he's fucked. You're fucked. You're fucked, son. All right, well, that's Decastro versus Wagner. You fucked, son. I'm going to close these off. All right. We're getting through them. All right, what do we got here? I got nothing. I thought there was more in Decastro versus LVMPD. All right, hold on a second. I'm going to do on Pacer because I might have to log in, and I'm not giving you asshats my fucking Pacer login. My bill's high enough. God damn it! All right, and what are we looking for? We're looking for 44, 44, and run report. Nope. I paid 10 cents for that. All right, so there's nothing in Decastro versus. I thought there was. Anyway. All right, so Wallace. I heard there was something in Wallace. Ooh. All right, we have an order on September 5th. Well, let's take us a little peeky poo. I don't need to say this. To date, parties have not filed a stipulated discovery plan. To the extent defendants seek to stay discovery pending the resolution of their motions, they must file a motion. If the motion to stay discovery is filed by that date, discovery will be stayed on an interim basis pending resolution of that request. If it's not filed, they must file a joint discovery plan by September 19th. Interesting. I'm told, by the way, by somebody, I forget his name, it didn't really matter, that it bothers him when I drink. So, I'm sorry, I'm hiding under the. Did you want to see my beautiful face? There you go. Is that better? Um, so somebody was upset that I was drinking, and um, he said in the comment section that everybody else who drank, it didn't bother him, but whenever I would take a drink during a stream, it would bother him. So, yay. I'm glad to be annoying. So, either defense is gonna file a motion to stay discovery by September 12th. You're welcome, Laura. Flick the bean a few times for me. And if they don't file a motion by September 12th, then they have to file a joint discovery plan by September 19th. So there's that. And then there's a motion to extend or shorten time. I slurp when I drink? Hell yeah, brother. Hell yeah. I slurp when I eat pussy too. How about that? There was your ASMR portion of the evening. Jethro Gull, you're drunk? Oh, man. Gotta stay sober, brother. All right, this is Floyd Wallace. We're on Floyd Wallace, right? Plaintiff's motion to extend time to respond. So, pursuant to FRCP 6, move this Honorable Court for extension of time to respond to their response to his motion to extend time, and an extension of time to reply to the remaining defendants' motion to dismiss. Did they these guys did they file something? Yeah, they had a motion to dismiss. Wasn't Marquis Arbach? Yeah. Okay. So why doesn't it show Marquis Arbach as the attorney of record for them? Laura, put it away. Put it away, Laura. All right. So we're gonna do this. Boop. Or in the alternative, for Lou to file a late reply in the interest of justice. So he's looking for an extension of time to file a reply to their response at 30. Am I retarded? Here's 30. There's a response. He wants to file a reply to 32. What is this? This is their limited opposition. Okay, so all they were doing was objecting to his further extensions and object to staying it. So he wants more time to file a response to that? An extension of time to reply to the remaining defendant's motion to dismiss ECF 33. Okay. This motion based on the attached memorandum points out authorities, pleadings, yada yada. I'm requesting until December 5th. December 5th? Holy fucking holies. December 5th. 3/39, and today's date is. He's looking for 80 days, 88 days. Fuck, that's a little excessive. Additionally, I've been delayed by me. Oh, Jesus fucking Christ. I've been delayed by being illegally jailed 3 times in the last 30 days. You know, if you don't want to be illegally jailed 3 times in 30 days, the best way to ensure that is don't fucking commit crime. What in the fuck is this guy doing? Additionally, since I'm currently traveling, I won't even receive the quote CD end quote the defendant submitted, assuming they mailed it to me, until after 14 days. You know, the traveling, like, it's not really an excuse. You're engaged in litigation. You filed it. You're engaged in litigation. It's not really like it's not really that much of an excuse to say I'm currently traveling. I was arrested 3 times in 30 days, and I'm currently traveling. Like, bitch, you probably out on bond. Like, fuck. Memorandum of points and authorities. For good cause, they could extend the time to answer. Uh-huh. Uh-huh. Discretion to accept late filings. Yeah. All right. Well, that's pretty fucking garbage, but okay. What else we got? Marquis Arbach. Good old Craig R. Johnson, Esquire. Hope this isn't shit like his last one kind of was. He's really letting me down. Off topic. I have a construction case that I'm working on. And opposing counsel is an old bull who's been doing this a long time. He doesn't know shit from Shinola. He's the guy who tells the young bucks what to do, and he's the generate paper kind of guy. He wants billing. He's a partner at a prestigious law firm out of Roseville, and I'm using the word prestigious kind of loosely. And the young buck was a court clerk until he got this job with this particular law firm, clerking for a federal district court. And they have been shitting out the absolute worst discovery requests, just shitting them out. It's bad. It's bad. The last round of discovery requests I sent out, they didn't include the required declarations with it for excessive discovery, and I got to object to literally every fucking thing they sent out as being improper because they didn't include the requested discovery. And they're probably the crux of their legal case is that my clients didn't follow ADA guidelines. My clients didn't follow ADA guidelines in construction. And I have attempted to explain this to opposing counsel before. And the discovery requests ask nonsensical things that just don't make sense. Like the old guy is having the young buck write all this, and the young buck knows fuck all. He's probably never touched a tool in his life, let alone work construction, let alone had a construction case. He has no idea what the fuck to ask or how to ask it. But he's asking a bunch of questions about the ADA. At the last deposition, he asked a day laborer, a guy who fucking he's the guy who would like do demo, like take down walls and shit, and then haul trash to the dumpster. He asked a day laborer one of his questions, and I fucking laughed in the middle of the deposition. He asked the day laborer, "Are you familiar with the Americans with Disabilities Act?" And this fucking day laborer was like, "No." Before I could even respond, I was just dying. Like, so in case you're wondering, why this is so fucking hilarious is guys who work in construction, they don't read the Americans with Disabilities Act. They don't know about the Americans with Disabilities Act. They don't fucking care about the Americans with Disabilities Act. They use building codes, and the guys who do the building codes are the engineers, the architects, and they send the plans to the city. They get reviewed to make sure that they're compliant with the building codes. The building codes are compliant with the Americans with Disabilities Act. Long story short, they have no fucking idea what they're talking about. Anyway, uh, sometimes guys at big name firms, guys who make a lot of money, a lot of fucking money, don't know what the fuck they're doing, and it's really infuriating. And this partner, Craig Anderson, this partner at Marquis Arbach, he's not been particularly satisfying to read. The other guy, who was doing it, the noob, he did better, I think. Since this guy's been doing it, uh, I forget what the other guy's name was, but they took him off of it. He was doing a better job, I think, because I think he actually cares, and I think he actually spends the time. Like the thing is, like the younger guys, they don't know what the fuck they're doing, and so either they're going to do one of two things. They're going to either go and figure it out, like go through the statutes, go figure it out, ask questions, find out the results, or they're going to ask the old buck. They're going to ask the old buck, "What do I do?" And if the old buck says, like like prefatory clauses, I'm getting all sorts of prefatory clauses and definitions in in the discovery request. It's so fucking stupid because they ask they have a defined term, documents, and documents includes all documents essentially, including communications. And then they have a separate definition for communications that are all communications essentially. I mean, you can figure out kind of what they are. I don't know why they needed to define these terms, but they'd ask for like all documents related to X, and then they'd ask for all communications related to X. And like you're fucking stupid because you're literally asking for all documents and then you're asking for a subclass of documents. You're fucking stupid. Oh my god, their discovery habits are just fucking terrible. They're terrible, and it just drives me crazy. But anyway, that's my story, and I'm sticking to it. So this beer is hitting really fucking hard, and I'm only halfway through it. I did not eat dinner, so there you go. I'm pulling a Josh when he gets all stoned on camera, except I'm using cheap beer to do it. All right. So, memorandum of points and authorities. Number one, introduction. Wallace is seeking an extension to respond to ECF 33. The motion was filed on September 1. He's requesting until December 5 or longer if the court grants it. The defendants do not oppose a reasonable extension of time for Wallace to respond to the defendant officer's motion to dismiss, but do object to the December 5th, 2023 request. Wallace is also requesting a second extension to file a reply to defendant's opposition to plaintiff's motion for sanctions. He is requesting extension until December 5th. He's already been granted an extension until September 25th. Wallace has had ample time to respond to this opposition, and LVMPD opposes any additional requests. You might want to put that in quotes next time, Shelley. You might want to put that in quotes because it sounds like you're saying that you, Wallace, have had ample time to respond to the opposition, which you have. So you might want to put that in quotes next time. Legal standard, extending time, yada yada. Legal argument: defendants do not agree to a lengthy extension for Wallace to oppose defendant's officer's motion to dismiss. Wallace has never requested an extension from the defendant officers. Maybe he means prior to this, because then he goes on to say the defendant officers do not oppose. He would know if they don't oppose unless he's asked them for an extension. However, they do oppose a 3-month extension, which I would. Like, who wouldn't? That's ridiculous. The defendants are agreeable to extending Wallace's deadline until October 15th. That's reasonable. It should not be difficult for Wallace to oppose defendant officer's motion. Well, it probably will be. It probably will be difficult for you to successfully oppose it. I don't think has Chile actually successfully opposed any 12b6. I'm thinking, and I don't think he has. He's skirted a few by filing amended complaints and things like that, but I don't think he's ever successfully opposed a motion to dismiss. So it's never difficult for him to do it. It's just impossible, apparently, for him to do it effectively. On July 17th, defendant LVMPD filed this motion to dismiss. The defendant officer's motion's arguments closely mirror the arguments in LVMPD's motion. LVMPD's motion would be based on Monell liability, so I don't think so, but I don't think it would. I don't think it would. Because Monell liability is basically irrespective of whether or not the officer, an individual officer, violated your rights. It's for a practice of violation. Caphalia says, what degree would help the most with a practice? Something like a writing or English degree, asking for a friend. I have an English degree. I don't know exactly what would help the most. I would almost lean towards business or finance. And the reason why is because running your own practice and having to deal with all the financial aspects of it is probably the most time draining thing. Although if you get a office staff suitable to help you, it does cut down a lot on that. Really, I think the reason why any bachelor's degree will allow you to go to law school is because really for any degree you would have written enough. A law degree. I think Cathalia is asking what undergraduate degree because yeah, I have a BSc in organic chem and a English degree. I'm assuming it would be pretty effing useless as far as I can tell. Well, no, because you would have written some papers somewhere along the way. Most attorneys, I think, my opinion is most attorneys they try too hard to church shit up, and really, the court doesn't fucking care. Your client would prefer not to pay you to church shit up. Opposing counsel would prefer it if you didn't church shit up, and if you just made basic statements of fact. This happened, then this happened, then this happened, then this happened, then this happened, and then follow up with concise statements of the law. Then I think everybody be the happiest. So I don't know. I mean, that's tough. It's tough. It's tough call. I know people who've come into practice of law from just about every undergraduate degree imaginable, and I don't know that any one is better than the others. So sorry for my non-answer. But apparently, it should not be difficult for Wallace to oppose the defendant officer's motion. Brevity is the soul of wit, and it's not the soul of rambling on a live stream. Banned legalese, says GMK lawyer at law. It blows, along with all firearms. No. I don't think any words should be banned, nor do I think any firearms should be banned, because the First Amendment exists as well as the Second Amendment. So that is about the dumbest thing you could have possibly said. On July 17, 2023, defendant LVMPD filed its motion to dismiss. Defendant officer's motion closely mirrored LVMPD's. On July 26, Wallace opposed LVMPD's motion. Thus, Wallace has shown the court that he is able to draft and file an opposition. Was that in question? Was that in question? I don't think it was. Logan Sandman says, whatever degree you get, take a typing class. That doesn't matter. You could take as much time as you need to type out your documents, and you get paid by the billable hour, generally speaking. So yeah, why would you do that? It doesn't matter. You'll get better at typing by typing. I don't think you should take a typing class necessarily. And if you want to, sure. Merba Trigger, says Laura Rader. He likes his firearms. I do. I do. Well, like one of the safest places I feel like I've ever been was at a bar in Montana. I went up there to go elk hunting, and I'm sitting in this bar in the evening, and people were coming in with firearms, like they were leaning their rifles up against the wall, and a lot of them had pistols on their hips. I'm just like, what? Because in California, if you enter a bar with a firearm, boy, howdy. Well, if you go anywhere with a firearm, like they're just rolling around with firearms. I mean, it's pretty crazy, pretty awesome. And yeah, I didn't feel in danger at all. I mean, if anybody had got out of line, there was like 20 other dudes there who would be more than capable of stopping any silliness. But I don't understand why he's saying that he's shown the court he's able to draft and file an opposition. I mean, it was a shit opposition, number one. And was that even in question? Therefore, Wallace's current request to extend the deadline until... So because Wallace is capable of drafting and filing an opposition, wait, it's unreasonable? More importantly, Wallace has failed to articulate any good cause for such a lengthy delay? What in the actual fuck? Are we missing quotes again? Did he mean to put this section in quotes? And why would he? Why would he quote this? What the fuck is going on? Am I retarded? This is Wallace's, right? No. Okay. All right. I am retarded. But why does this matter? Wait. Why is he saying? Why is Marquis Arbach saying that the it shouldn't be difficult because... Oh, fuck me. This beer must be hitting harder than I thought. Is he really saying that LVMPD's motion to... it's not Decastro, it's Wallace. Wallace. So, motion to dismiss standards, and then Monell standards, and then what? He's talking about the Monell claim. So these are all dealing with the Monell claims. He's still arguing the Monell claim. I see subsets under the Monell claim arguments. He is arguing what the officers apparently would argue. I guess, sure. And okay, so Wallace has not articulated a good cause for such lengthy delay. That's correct. Jesus, this beer's hitting harder than I thought. I don't know if I'm qualified to continue on reading this shit. Defendants opposed Wallace's request for an extension to file his reply to their opposition to his motion for sanctions. Wallace immediately filed an unopposed motion to extend time, yada yada. Wallace requesting extension to the 25th or longer. Defendant oppose. This current request makes no attempt to establish good cause for additional extension beyond the requested September 25th date. Defendants object to any extensions past this September 25th date. All right, so he's representing all of them. All right, whew. Whew. You know what? I may or may not stop. How about that? How about them apples? How about them apples? All right. Fuck it. We'll do it live. And I can't go all the way back. Well, that sucks. So we're going to start off with the Unforgiven Jerry at Logan Salmon. Hey, I like how Merb is on our time zone. Feels good to see someone under the same sky. Logan Salmon says at the Unforgiven Jerry, no kidding. Michelle says James is absolutely part of the press. Absolutely he is. The Unforgiven Jerry asks, I'm a part of the press too. Yes, you are, Jerry. If you want to be. J5 says Michelle agreed, but that doesn't give him the right to do what he does. True. Just because you're a member of the press doesn't mean that you can do whatever the fuck you want. There you go. Now you get to see my beautiful shining face. Logan Sandman says, and it looks like his camera is facing west. Hold on a second. It is facing east. That way is east. Well, kind of slightly that way is east. Yeah. Michelle says he may not have a right, J5. However, I believe he should. A right to what? Be a dick in court? I don't think so. Rodent, no last name, says, I am an investigator. Well, good for you. Don't forget, Jerry says, so I could print stories that Merb is beast. Well, that would be filed in the fiction section. J5 says, Michelle, you believe he should be abusive and flout rules that other people have to follow. Well, I think James's position is that other people should not have to follow those rules. J5 says, Benny Franklin was a huge slut, too. Oh, good for him. I mean, it's not like they could spend a lot of time watching videos or something. Michelle says, I didn't say that, J5. You kind of did. You maybe didn't mean to, but you kind of did. J5 says, Michelle, so what should he do? So he should do what then? Brazo says, Merb, if courts and government buildings can ban firearms, as per Heller, why not cameras and cell phone? Well, I think I answered that. It's because one is a Second Amendment protected right, the other one is a First Amendment protected right, and they have different standards, different tests. And generally speaking, I'm not sure that government buildings can't ban them, but it's a different test. It's a different test. Michelle says, what I said was my opinion is he should be able to film in the court. I understand many don't agree with that, but that's my opinion, and you're entitled to it. And it's not just because you show me your butthole in DMs. Oh, did I say that out loud? My bad. I'm joking. Michelle doesn't. The Unforgiven Jerry says, can I write stories about Ben Franklin doing that kite thing as part of an orgy and only stumbled on the electricity thing because anal beads were made out of copper? I think Nasty Nate might buy that book. Henry Walsh says Project Veritas is a bad take as they were scum. Well, fuck you, Henry Walsh. J5 says, Michelle, I don't share your opinion, but I understand your viewpoint. Michelle says, and I understand yours, J5. That is lovely. Look at them coming together. Paige says, wow, Merb hard simping for Veritas. Show me your boobies. Henry Walsh says, that's not what I said, but I literally read what you said. J5 says, Project Veritas indisputably lied clearly on that fetus body part selling video. Mervis, you could say they didn't, but you're wrong. I haven't seen that video, so I can't say whether or not they lied or not. Also, I don't know what they would or would not have lied about, and whether I would be in a position to know if they lied or didn't lie. I go by their court record. So that's all I go by. The Unforgiven Jerry, shit no lie, look at Blue Bacon. I don't want to look at Blue Bacon. He wears a Hawaiian shirt in the pool. Why would a man wear a Hawaiian shirt in the pool? I could see wearing a Hawaiian shirt beside the pool. I could see wearing a Hawaiian shirt around the pool. I could see wearing a Hawaiian shirt pretty much any time, place, or location. But in the pool? Really gets the noggin jogging. Makes you think. Motherfucker wore a Hawaiian shirt in the pool. Like, I'm not going to take my shirt off, even though it's a button-up shirt that is colorful and probably won't react well to being in highly chlorinated water. I'm going to jump into the fucking pool in my Hawaiian shirt. What is wrong with that boy? Paige says, I have seen, quote, stories, end quote, Veritases put out that, in my opinion, and we can stop there. Mr. Showbar says Ben Franklin had numerous illegitimate children. Good for him. Michelle says working for corporate media means you have ethics. LMAO, proven untrue. I believe so. Paige says, I don't give a fuck what they stand for or against, but you are asserting that just because they weren't found guilty in court of something, it didn't happen. No, because guilty would imply that they were in a criminal proceeding. So I didn't state that or imply it. Show me your tits. Mr. Showbar says Ben Franklin was made ambassador to France to get him out of the way of a new government seeking legitimacy. I think there were other reasons for him being made ambassador to France as well. And he got the French to fight on our side in the American Civil War. So, I mean, that's something. That's something. J5 says, democracy is the worst form of government, except for all the others. That is a Winston Churchill quote, and I've used it before. But then I became an adult, and I realized that democracy is just a way for the people to be authoritarian over other people. Because a democracy is literally two wolves and a lamb sitting down to dinner and voting on what to have for dinner. So the founding fathers were like, well, we need some sort of protection against that, so we're going to be a republic. We're going to be a nation of laws, and the laws are going to be there to protect the sheep who would get voted against for dinner from the wolves who would be having a nice lamb dinner. Except when you create a republic, you get a lot of corruption because you have people who get elected, a small group of people who get elected to enact laws. Now, for example, if you wanted a democracy to vote your way, you would have to bribe 50+% of the population. And then voting your way would most likely be in their favor because they're literally getting paid to do it. As opposed to a republic where you only have to bribe a handful of people to vote your way. And so you can take control of the nation, not at what's best for the majority of the people, but at what's best for you. I find, and you can tell me I'm wrong, but every government can be authoritarian. Every government can limit or eliminate freedoms. And like for example, Coded went to Hong Kong, which is China. It's China. It's been reunited with China. It's China. And he had a great time. And he didn't talk about at all about how he was repressed. And people there buying and selling. There's normal commerce going on. It's a communist country, but everybody's exchanging goods and services for money. I mean, it's right. And then you hit and people elect. You only have one party you can vote for. You can only vote for the Communist Party, but I'm sure there's different people running for different positions. They're just both in the Communist Party. I'm guessing at that point. I don't really know. But you look at that, and then you go to someplace like Singapore. Now, Singapore, there are laws against chewing gum. You can't chew gum in Singapore. It's a democracy. You can't chew gum in Singapore. Authoritarianism, the lack of freedoms, has nothing to do with the actual government itself. Like the what we think of as the government. And at the end of the day, I think one of the big problems is that in democracies, you have a lot of very uneducated, very stupid people who are allowed to vote and who vote in what they perceive as their best interest, but they don't really know what their best interest is. Which is why we have laws like seatbelt laws, because we understand as a society that most people are going to make shit decisions when left to their own devices. But they can vote. So we're like, hey, you need a law that says you have to wear a seatbelt. And at the same time, we understand that you're too fucking stupid to figure out that you need to wear a seatbelt. But we'll let you vote. You're too stupid to figure out seatbelts. But you can vote. And this isn't a problem, apparently, for most people. Republics, you're going to get better informed people, generally speaking. The people who go to Washington, they're probably much more informed, but they're bought and paid for. Every single one of them. We have the illusion of choice. We have two people presented to us by the Uniparty, and we get to pick one of the two people. We don't get to pick who we're going to pick from. Bernie was robbed. When the first time around, Bernie was robbed against Clinton, and then the last one where every time anybody got any lead over Biden, all of a sudden they drop out of the race. They give Biden all of their electors, or delegates, excuse me. I mean, it's rigged, and Trump was an exception to that, which is why both parties fucking hate him, because he's not one of the approved people to run. And I'm not saying that's good or bad. He was a shit president. He just wasn't approved by the Uniparty. So the reason why I think monarchy is the best, because it removes a lot of the impetus, a lot of the. I mean, if a guy owns, he basically owns the fucking country anyway, he's going to be hard to bribe. And he might be lazy. He might be a piece of shit. He might be stupid. He also might be educated, because he's going to be the king one day, so they might educate him to be the king. And he might have the country's best interest at heart, because, it's happened before. And He might just love his country, natural patriotism. Might also understand that people might guillotine him if he doesn't. Might. You can get a shit king, but you could also get a great king. You can't get a great republic, like you can't get a great Congress. And people like oh, monarchy is terrible. Like, go to any monarchy and find out what the approval rating of the king is, or queen, or whatever, and then compare and contrast that to the approval rating of Congress. I think Congress is in the teens, like 15-ish. I mean, I've seen it low, like 12, 13%. I've never seen it above 20. I'm assuming it could, but everybody always hates Congress. And the president might have a 50% rating, probably less, probably. I mean, the citizens of the United States fucking hate their government. Like, it's garbage. Congressmen, zero trust in Congress, 10%, 12%, whatever. I mean, but find out how, like, I know the UK isn't a monarchy. Like, in reality, they've got a prime minister and everything like that does all the actual governing. The prime minister and the parliament, etc., do all the governing. But the monarchy has a very high approval rating. Yeah. Anyway, I'm gonna probably end it. Laura Rader says, "I think Merlin would make a fair, kinky, and maybe cruel king. I wouldn't be a good king. I wouldn't tolerate a lot of shit. Oh, a different Jay-Z says, "Oh shit, you're serious about it, Mark?" Yeah, I'm fucking serious about it. Like, I want accountability. I want accountability in the government. We don't have any accountability in the government. If we had a king, then if everybody reports to the king, and the king tells everybody what to do, then there's just direct accountability. Like, we're so terrible in the United States that, like, even our Congress has abdicated, and our executive branch has abdicated a lot of the decision making and decision enforcing provisions to bureaucracies, where people that have never been elected have more power than an individual senator or Supreme Court justice does. Like, it's fucking crazy. It's fucking crazy that we allowed that as a country to happen. Absolutely, absolutely terrifying. Like I know I don't have a lot of, maybe I have some Second Amendment people in here, but like the whole thing on like the ATF getting to decide what is or isn't allowable as far as like pistol braces. I don't have any pistol braces. I'm not a black rifle kind of guy. I'm not a big fan of ARs. I've got rifles and shotguns and stuff, but most of my shit's more geared towards hunting. I'm not a big AR-15. Like, it's fine if I ever bought one, it'd be great, but I'm certainly not going to buy one of the ridiculous ones California sells. And I don't know. I just don't really have a use for one. But giving the ATF the ability to basically, at a whim, determine what is or isn't legal, like, I mean, it just leaves so many Americans like clueless as to whether or not they're breaking the law at any given time. Like, why do we allow that? What benefit to the U.S. does that bring us? I don't think it brings us anything. And why people think that the U.S. form of government is so great, I just don't understand, because everywhere it goes, I mean, it's just always turbulent. Everywhere we export our system of government to, it's always turbulent. It's always prone to corruption. I mean, it's just not good. And people are like, Putin's a bad guy. Maybe he is, maybe he isn't. But they had a surplus last year, and what he did was he raised pensions by 15%. Russia had a surplus of income, and instead of like that money magically fucking disappearing, he took it and he gave it to pensioners. And it's like, here you go. You guys make more money now. I'm not simping for Putin, but I wish our government went. I mean, it's not like we ever run a fucking surplus, but I wish we had a government that would actually think about running a surplus. And when we had a surplus, we'd think about giving it, benefiting the people with it, And people are like, oh, I want socialism or whatever. Giving pensioners a 15% increase in their pensions, good. I don't fucking care, dude. Like, I would rather spend it on pensioners in the U.S. than spend it on fucking foreign wars or foreign bases or bombing brown people in the Middle East. Like, I don't fucking care about them. Why can't we spend that at home? He is bad, Burb. Oh, well, the people of Russia seem to like him. GMK says it's not the form of government, it's humanity. Well, Rome was once a republic without democracy. The wealthy class selected the Senate and bribed the pleb class for the rest. Yeah, and then they got kings and emperors, and there was some good stuff, and then there was some bad stuff. Britt Biatch says, "Have you seen Putin's palace?" Putin's palace. Let's look up Putin's palace. Putin, because last I heard, Putin spent most of his time at the in Moscow. Putin's palace. It was built in 2005. The complex first came to public attention in 2010 after whistleblower Sergei Kalashnikov published an open letter to Russian President Dmitry Medvedev exposing the construction of the palace. This guy also said the undertaking was run by this guy who was acting on behalf of Vladimir Putin. Alexander Pomenenko was later reported to have ownership. The complex drew more substantial public attention in 2021 when Russian opposition leader Alexei Navalny's Anti-Corruption Foundation released an investigative documentary film. We can't trust Project Veritas, but we can trust investigative documentary films. Documentaries never lie. About it, which detailed a corruption scheme allegedly headed by Putin, and claimed the palace was built for the president's personal use. The FBK, the Anti-Corruption Foundation, Putin denied the palace belonged to him, with the Kremlin saying that it is a private venture owned by various businessmen whose name cannot be revealed by the state. Following the release of the film, this guy, who has close ties with Putin, claimed ownership of the palace. Okay. Environmental Watch for the North Caucasus investigated it, and they said that they were harassed by members of the Federal Protective Services. So there is some place that is allegedly. Oh, you couldn't see any of that. What are you even looking at? Why can't you see that? Oh, you can. You can see it. So, wow, that's compelling. And it's built with public monies that even Wikipedia didn't say it was built with public monies. But I guess, there's the establishment of contracts and charitable funds with 35% cut. The cash flow scheme. There's a Germany's responsible. Sorry, Germany's responsible. You're wrong. Germany's responsible. If anyone needs me, I'll be in the angry tree. Nice. Enjoy yourself there. Rub one out. Putin increased the pension by 50% while inflation was up 50%. Inflation was up 50%? think it was 2022. We'll go with 2022. An all-time high of 20.3% in April of 2022. Hmm. 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 2022, there was a spike there. This place doesn't even say 20.3, and then it's dropping 2023. That's fucking crazy. That's fucking crazy. This chart shows it got up a little over 17.5%, but our realist 170 says Putin increased pensions by 15%, while inflation was up 50%. Now, fuck facts, fuck charts, fuck any sources. It just was. Just listen and believe, folks. Because Putin's a bad guy. So he had to have done, if he gave everybody pensioners a 15% increase, it had to be. It had to be because inflation was up 50%. We want more through Mission 22. I should hit up Putin. Well, you should definitely donate to Mission 22. And I'm just guessing that considering the sanctions, I don't even think Putin could donate to an American charity. I'm not sure he would. He might be a little miffed at what America's doing, funding Ukraine. Yeah. Laura Rader says hashtag free Alexei Navalny. I don't care, but dissidents and political opponents should not be imprisoned or poisoned. Lol. I agree. Unless they've committed an actual crime. Like just because you shouldn't get a free pass just because you're a dissident or political opponent. Like James Freeman could be a political opponent or dissident, but if he breaks the law, then he should be punished for it, right? Fallacy says, trust me, bro. I do trust you. Britt Biatch says he also had his own people arrested for holding blank pieces of paper. Well, Britt Biatch, the January 6th protesters, some of whom weren't even at January 6th, were arrested. And like, who's that? Oh God, there's somebody. What's that organization? Oh, it's like the Good Boys Club or something like that. Oh, not Oath Keepers. It was something like Oath Keepers. But anyway, the leader of this particular group, who's not white, but apparently the group is a white supremacist group, he just got 22 years, and he wasn't even at J6 for the J6 protests, and Biden's organization are busy doing their damnedest to try to put Trump in prison for shit that never has ever been a crime before. Proud Boys, thank you, Jay Verse and Emma Willard. Yeah, I mean, 22 years for inciting a riot where the only people who were killed were the rioters. Yeah, it's fucking crazy. The black white proud dude. Yeah, exactly. Like like fuck reality, fuck facts. Like don't believe your own eyes. These guys are white supremacists with a black leader. Just don't believe your own eyes. Uh, uh, Brit Bitch says, "Will Putin donate to Trump's legal fund?" Yeah, you know what's fucking weird? You know what's fucking weird is that people are like, oh, Trump and Putin were in bed together, but then as soon as Trump's gone, then Putin decides to intervene in the Ukraine. Isn't that weird? That's fucking weird. Many got longer sentences than rapists in those charged offenses. Yeah, yeah. I mean, there have been lots of similar things, a lot of protests, like the Kavanaugh protests and things like that. Lots of very similar protests where similar nothingness happened, and people normally get like misdemeanor, slap on the wrist, time served, or a fine, something like that. And yeah, Realist says before the invasion, USD to ruble was $1 to 70 rubles. Today is $1 to 98 rubles. Okay. I don't know what you're going at there. The value of a currency is not a proxy for inflation. Uh, Countries oftentimes want to keep the value of their currency low and try to keep it low to stimulate exports. And Russia has historically tried to keep the ruble low. China, U.S. has always been upset with China for trying to keep their like the yuan or whatever. I forget exactly how they pronounce it, but conspiracy is agreement to act in furtherance. You didn't have to be in order to be convicted of seditious conspiracy. Somebody has to fucking do some sedition though in order to be convicted of conspiracy, or there has to be some actual attempt at sedition, or agreement to commit sedition. And I don't believe Miss Willard that any of that happened. Again, like there's so much bullshittery in the J6 stuff. Like I'm gonna say no. There's way too much nonsense. There's way too much nonsense. The only person who was killed was the one gal who got shot in the fucking face or something, and she was a protester. And if she hadn't been a Trump supporter, she wouldn't have been shot because they've never shot protesters like that before. There have been a lot of fucking protests at the Capitol. So, no, no. Anyway, this is getting a little too political. I'm just going to go with we need a king. And Ukraine was on a path to join NATO after Biden took control, so Putin invaded. Ukraine was on a path to join NATO after Biden took control, so Putin invaded. Well, that's a complicated tale. Putin wouldn't have invaded if they had done certain things, among which would be not to join NATO. But to suggest that was the president of the United States does not control who does or does not get into NATO. Every NATO state has to agree to it, and it's not up to the president of the United States necessarily. So other NATO members can veto it. That's what Turkey was doing with Finland and Sweden. They were holding out their agreement to allow those countries into NATO. And also, Putin invaded. I think Putin would say that he didn't invade; that he intervened in an ongoing civil war between Ukraine and the Donbass states. So, isn't it weird how everybody in here is parroting the standard uh, mainstream media narrative at me? It's fucking weird, isn't it? Fucking weird. Anyway, thanks for watching. Have a great day.